welcome to all our various students, guests, and so forth. It's a great pleasure to have this symposium here, and in particular, in addition to having former colleagues who came to join us, we have a couple of really outstanding guests. So what I'll do is I'll say a minute about how the structure of this is going to be, then I'll introduce our various speakers, and then we will just get going. So in terms of structure, we're going to have first the keynote presentation by Professor Bill Kovacic that I'll introduce in a moment. And then we'll have comment from Professor Baker and our very own Professor Maciá. After that, we will basically move from sort of presentations at the podium to kind of a more roundtable format. I'll guide a conversation, discussion, debate, if there is any, among the speakers, and then we'll open it for Q&A. So if you have questions along the way, just kind of collect them, and we'll make sure to have enough time for at least as many of you as we can to get their piece and get a reaction. So our keynote guest today is Professor Bill Kovacic. He's the Global Competition Professor of Law and Policy and Professor in Law at George Washington University Law School. He's also the director of their Competition Law Center. I'll give you a little bit of his history before I focus on the parts of it that are particularly pertinent to today's conversation. But before joining GW in 1999, Professor Kovacic was the George Mason University Foundation Professor at the Law School George Mason since 1986. Before that, he practiced for a number of years at Brian Cave's DC office. In recent years, Professor Kovacic has done, or not so recent even, a really impressive amount of international work. I would say just from my own sort of moving around the world, and New York in particular, but all around the world, that Professor Kovacic is, if not the preeminent, definitely one of the most preeminent antitrust scholars, practitioners, enforcers, and sort of policy people in the space that sort of everybody around the world recognizes as a very important contributor in the field. Just to give a few examples of that, between 2013 and 2022, for 9 years, Professor Kovacic was a non-executive director with the UK's Competition and Markets Authority. For those who don't know, the CMA is basically their overarching antitrust agency, which has a very unusual structure at the time, that they had some non-executive directors that were non-UK people, some of them, and specifically they invited Professor Kovacic to serve in that role. He spent a number of years in the International Competition Network as a vice chair for outreach, and advised too many countries and governments and international organizations to actually name here and finish today. So I will not do that. A little bit of Professor Kovacic's earlier education. He had a BA from Princeton in 1974 in public and international affairs. What caught my eye was that after college, he already spent a year on the staff of a Senate Committee on the Judiciary, but was interesting that he was on the staff of the Subcommittee on Antitrust and Monopoly, and that's just after college. So it seems like he had some interest there from early days.
I delivered a lot of coffee to members of the committee.
Yeah, exactly, and that surely made an impression.
Yeah, it did.
And after that, he went on to Columbia Law School, and got his JD there, did the practice that we mentioned, and in addition to the academic work that I mentioned, what's most pertinent for today is Professor Kovacic was the FTC's first general counsel from 2001 to 2004, and in fact, even though I met him a couple of times in other capacities as on the academic side, that was a time when I overlapped with him when I was an attorney advisor to one of the commissioners on the committee, and we got to interact. And after that, Professor Kovacic also continued further to be not just an FTC commissioner between 2006 and 2011, but during that time, he also served for a year as the chair of the Federal Trade Commission, on which we're going to talk about greatly today. And by the way, there's this theme. So I met him when I was an attorney advisor. Of course, he was an attorney advisor a couple of decades before. And when we talk in a moment about Professor Baker, so there's a running theme here of people who at least worked on some rungs of the ladder. I never had any ambitions to go beyond that in government. That's okay. Please don't call. Okay, so this is Professor Kovacic's background. I think it makes him uniquely suited. There are very few people who not only have the international perspective, the domestic perspective, but really understanding the FTC sort of inside out, having lived it in so many different iterations over the decades. I think it'll be very valuable to hear. As our first commentator, we have Professor John Baker, who's recently emeritus from American University Washington College of Law in DC, where he spent about 24 years on the faculty. Professor Baker is also a very prominent antitrust economist and lawyer, though he really worked a lot as an economist. His education sort of started with bouncing back and forth between Harvard and Stanford. Got a BA at Harvard, then an MA in economics in Stanford, then back to Harvard for a JD, then back to Stanford for a PhD in economics. So, they didn't give such good miles at the time. This is the late 1970s, early 1980s. Anyway, Professor Baker, in addition to an illustrious legal career and a very extensive portfolio of consulting on antitrust cases of all sorts, including cases that the antitrust students here in the class would have heard of, from the recent Google case, going back to some earlier case, like I saw text messaging. Those of you who did antitrust should recognize that, for example, as a part and parcel of any force in the field. He was a chief economist of the FCC, the Federal Communications Commission, from 2009-2011, director of the Bureau of Economics inside the Federal Trade Commission, the FTC, from 95 to 98, and then consultant with him for a number of years. As I mentioned earlier on, 1985 to 86, he was also an attorney advisor to an acting chairman and one of the commissioners of the time. He was also at the Council of Economic Advisors as a senior economist from 93 to 95. And another thing I did not know, despite knowing John for many years, that he actually started out some of his academic career after he worked for 3 years at Foley in DC as an assistant professor in Dartmouth and business administration for 4 years in Tuck at their business school. So very, very illustrious and very diverse background that will bring a lot to the conversation. Finally, our second commentator doesn't need much introduction, our own great Professor Maciá, that many of you are now taking the class with us, and those who don't, I'm sure, know and heard about her. So without further ado, let us welcome Professor Kovacic. Thank you.
Thank you very much, Avishalom. It's an enormous honor for me to be here today with you. It's a delight to be at this wonderful university and its law school, and to be reunited with you, and indeed to continue to see John, just a fabulous co-author, collaborator over the years, and to be part of the entire symposium. Thanks for inviting us to be here.
I did not mention that co-author, among other things, on one of the most notable antitrust case books.
Yeah, if you're wondering about gifts for the holiday season, I can only assure you that attracts great gratitude. And I especially recommend the deluxe leather-bound edition, which we'll be glad to sign for you as well. They're getting the food out of the way, but there'll be copies outside. We'll be signing for you and add it to your already modest bills here. So glad to do that as well. But thank you for the tip, and to have again. Those who taught me so much in my own work to be here with me, I'm extremely grateful. I want to talk about what a little over a century ago, 110 years ago, was an exceptional innovation in the field of public administration and economic regulation. We are in many ways familiar with and overwhelmed by the developments in commerce that have taken place within our own lives, yours and mine. But there was an earlier era where astonishing things were happening in the commercial marketplace. From a period roughly the last 20 years of the 19th century into the first 25 years of the 20th century, we have an astonishing array of innovations come forward: the automobile, the telephone, the airplane, the original wireless radio, moving pictures, and then talking pictures, alternating current as a source of energy. All of these things happen in a breathtakingly short period of time. They're concurrent, dramatic, transforming events in the field of commerce and transportation, finance, communications. The changes at the time seem no less remarkable than any of the changes we're observing now. And Congress established a new regulatory body to address developments in that field. In many respects, the Federal Trade Commission was a response to that exceptional change in behavior. The future of the agency, in many ways, may be up for grabs now due to a variety of considerations. We have a new Department of Government Efficiency, the DOGE. I suppose the Venetians might want to seize back that acronym and say you can't use that, that's already accounted for, but we have it. Whether this is gone in 6 months or not, I'm not sure. Two fairly headstrong individuals crucially involved in doing this. I don't know if the universe has room for both of their egos, but we'll see. If I were running a betting line, I'd say over or under the line is about July, but we'll see. One of the mandates that it has is to take a look at government performance. Not simply aggregate expenditures, but to look at areas of redundancy and overlap where it might be possible to save some money, improve the performance of government by eliminating overlapping functions. There's an administrative law and a constitutional law turmoil taking place in the courts today, an examination of a number of assumptions that all of us have lived with about the operation of the administrative state, local right being one of the shocks, but others like SELA that take a look at the allocation of tasks within agencies, and a number of cases in the courts, perhaps picking up on hints that the Supreme Court itself has given, making their way through the judicial process, probably coming back to the Supreme Court, that look at a number of fundamental assumptions about the operation of the administrative process, including the ability of the president to remove individual members of regulatory boards without cause. Continuing concerns about how big tech should be subject to government oversight. In the framework of existing laws and policies, do we need the addition of new regulatory frameworks to provide more protection in the field of data protection and privacy, to apply new competition laws, to adopt variants of what other jurisdictions have established under the rubric of the Digital Markets Act of the European Union, the Digital Markets Competition and Consumer Act in the United Kingdom. Might the United States adopt some mechanism, its own version of these approaches by way of new legislation and maybe a new agency to do it? In all of this, the FTC is a focal point for discussion. Maybe not just focal point, but target for some of the initiatives. Its mandate is quite remarkable. It's got a competition mandate, it's a consumer agency, and it is the principal U.S. data protection and privacy authority, which could be very useful as a platform for doing big tech regulation in the future. And to anticipate one of my conclusions, I think this is a reason to carry forward with the configuration that the FTC has now. I have a hearts and minds problem on this, though. As Avishalom mentioned, I've worked at the FTC on a number of occasions. I have a deep and abiding affection for it and its people. And I have a very hard time writing a line of print that says it's time to give up. To say that after 110 years, perhaps we should try something else. So I'm not going to say that, although there were certainly days at the FTC that I thought maybe that was the inevitable destination for the agency, certainly for its competition mission. But I'll say what I think the agency has a useful role to play in the future, but I'm going to identify the many critiques that have been made about it. I will note that to begin with, the literature on the FTC from its beginning is fairly mournful. It's hard to find commentators who generally approve the direction of travel of the agency, blue ribbon panels that had good things to say about it. It's largely a literature of disappointment. Basically, the literature you find that speaks approvingly of its performance, especially as a competition agency, tends to be written by people who had senior leadership positions there, talking about their own time of service. So maybe not the most reliable set of observers and evaluators for how the agency had done over time. I'm going to talk a bit about the initial design and aims of the establishment of the agency, again, which Congress saw as an extraordinary source of innovation in the field of administrative decision-making. A little bit about the agency's evolution to the present, strengths and weaknesses that the agency faces in executing its mandate, and then to finish by saying why I think the agency still has a good role to play. If we do have new legislation for the oversight of big tech, why the FTC is well suited with some adjustments to be the platform to do that. In 1914, this is in many ways a revolutionary design. The fundamental mandate of the agency was that it would have the power to prohibit what are called unfair methods of competition. The statute didn't define what those were. Legislators concerned that this was an excessive delegation of authority. Footnote, the Supreme Court might come back on this and say, yes, that was an excessive delegation of authority, but a broad mandate to set new standards of business conduct. And the question was, don't we have to say something more about what we want the FTC to do? The prevailing view was you could write down 20 specific practices and business would develop 20 more. So you need a very flexible mandate in order to enable the authority to adjust to new economic circumstances and to establish standards of behavior not previously recognized under the interpretation of the Sherman Act at the time. So we need a deliberately flexible, scalable mandate to enable this agency to address new circumstances and to prescribe specific forms of business behavior. That's a pretty astonishing grant of authority to a regulatory body, packed into this brief description, unfair methods of competition. The mechanism for implementing policy would be administrative adjudication. The agency would have what were then called hearing examiners. We would call them now administrative law judges. The board would decide to bring a case, initial adjudication before the administrative law judge, and then an appeal back to the board itself, which would write an opinion that defined whether or not the behavior in question was illegal or was acceptable. Again, an important institutional choice integrating the functions of prosecution and adjudication. In most areas of the law, we don't trust that framework. But for administrative adjudication, certainly here, Congress did it. No independent mandate to go to federal court. The original FTC had no, what we would call today, independent litigating authority. That means the ability to bring cases directly in federal court. The mechanism for performing this elaboration of standards would be the adjudication of cases within the FTC itself. This could be seen as a specialized court. Congress thought that giving the Sherman Act interpretation simply to the federal judges gave generalists an overwhelming burden. They weren't well positioned to handle. It was much better to have a specialist board, a group of experts that through repeated exposure to specific problems, based on the expertise they bring with them and extraordinary research and development capabilities inside the agency, would become the preeminent forum for resolving competition policy disputes in many respects. The trade-off to do this new, almost lawmaking function through adjudication was that the remedies were very light touch. The remedies were forward-looking injunctions, no mention of structural relief, certainly no capacity to impose criminal sanctions, that would be the Department of Justice alone, no ability to obtain monetary recoveries. So in order to remove some consequence to firms who were told what you thought was acceptable behavior is no longer acceptable behavior, the only remedy would be to say, stop it and don't do it anymore. Forward-looking injunctions, relatively broad interpretation authority relatively light touch remedies. But it's going to be crucial to this. A multi-member board, 5 members, a political diversification requirement, no more than 3 from any single political party. But Congress spoke about the benefits you get from having the opportunity to appoint people with diverse expertise. Not merely lawyers, of course, but definitely economists. My interpretation of the legislative debates is that there'd be an economist, one professional economist on the board at all times. Some representatives with business experience, people whom the legislators refer to as publicists. These are people who are skilled in public affairs, public communications, outreach. The board would be special because those appointed would come from exalted backgrounds. They'd be people with demonstrably great stature in their fields, and you'd have a board that could discuss solutions to problems from a wide range of perspectives. Of the over 100 individuals who have served as members of the Federal Trade Commission, anybody have a guess of how many have been economists in 110 years now? Over 105 members. Well, that would be 4. 4 out of over 100. Not quite the fulfillment of the ambitions that were packed into the original group. Who have been the members? Overwhelmingly, yes, indeed, lawyers. Lawyers and lawyers and lawyers. Never an engineer, never a computer scientist in the modern era, which might be good for tech, maybe. Lawyers. Who, for all their great capacities, might not be the best position to do work in this digital environment. The last key element was an extraordinary research and development capacity, which was built into a feature of the statute that allowed the FTC to do investigations and studies without regard to a pending law enforcement matter. It was basically a mandate to go study industry or current commercial problems using compulsory process to gather business records and to instruct companies to create data sets which would be presented to the commission at the commission's request. So an astonishing capacity to simply examine and study commercial developments. This would be the foundation on which you fed back into the agency an understanding of industry that would allow it to be the truly superior adjudication body, because it would have this enormous understanding of industry to draw on. And this would be used, among other things, to advise courts in the formulation of remedies. There's a provision in the statute that allows those courts in monopolization cases to ask the FTC to act as basically an advisor to the court on the formulation of remedies. It allows the Department of Justice to tell the court, you ought to bring in this other agency to help out here. Don't count on that happening in the current Google case. The Department of Justice is probably not going to ask the court to bring in the Federal Trade Commission, although that was a possibility to use this great body of knowledge. How many times since 1914 has this power been used? That would be once. In the teens, in a case where Judge Learned Hand, before he became a member of the Second Circuit, said, I want the FTC to do a report for me. The FTC began the project, the case settled before it was done, never used again. But the FTC in many ways was thought to be the remedies agency that would become a unique repository of understanding about how you go about constructing competition in the face of successful monopolization, where dominant firms had acquired a preeminent position. How would you go about fixing that in the design of remedies? That was going to be the FTC's job too. The assumptions about making this work, that is what was crucial to the model. One is that you were going to appoint people with exceptional capability. Some of us, of course, had that. Not all have. A large number of appointees over time become the products of political patronage appointments. Congress over time and the White House think, well, as long as you have a majority of the 5 who are real experts, that's good enough. 3 out of 5. That degrees over time to at least the chair ought to know what she's doing. A 1 out of 5 will do. Beyond that, well, it's not a broad spectrum of the population represented, and there's expertise in many forms that we ought to respect. That's equivalent to saying you could take the 10th person coming out of the metro and say, want to be on the Federal Trade Commission, you're on. A large number of failed seekers of electoral office, people who then voted out of office. To a great extent, the great expectations about expertise not fulfilled, least of all the diversification. Never an engineer, 4 economists out of 100 plus, not great diversification. And this special knowledge would be crucial with this agency that has the broad mandate to set priorities and pick good projects. If you're told your job is to go and address unfair methods of competition, that puts a real premium on your ability to decide what to do and how to do it. What are the priorities? What should we be doing in this big economy? What should we be looking at? The most important function, I think, that a board performs in a government agency or a single agency has is to chart the direction for the agency. What are we meaning to do? What project should we pursue to do that? That's the most important thing that leadership does, is to make those choices. Well, the key assumption behind the FTC is that you've got a really superior board that's going to guide that process. Second is that the agency is going to have a key role in establishing new boundaries of doctrine, what Dan Crane at the University of Michigan has called norm creation. It's going to use this ability to define unfair methods of competition as the tool for doing that. This means taking boundaries that have been set by the interpretation of the Sherman Act and going further to address new forms of behavior. And because you're such an expert agency, well, the courts are going to defer to you in this process. Generous judges are going to look at your work and say, oh, I'm not going to second guess that brilliant Federal Trade Commission. There's a provision in the law that speaks about respecting findings of fact that are supported by substantial evidence. That's a rough way of saying they get the benefit of the doubt if they've put forward evidence that supports the hypothesis of harm that they've established. And their judgment about what evidence is most important will be respected within certain limits. And certainly Congress, which has told them, you go establish new principles of business behavior, they're going to respect these choices too. The legislative debates include objections from some members saying this is a lot of power to give a government body. In some respects, they're establishing new law. Well, constraints, well, there will be judicial review, but the leading sponsor of the FTC Act in the Senate said, don't worry. Yes, it's a lot of power. It's a lot of authority. If they misuse it, we will destroy them. And essentially what Albert Cummins said is a key condition of using this framework is that we, Congress, will be deeply involved in ensuring that it's used well. That means Congress is going to be exerting oversight. Do they use it constructively or not? But they will be involved as the mechanism for overseeing whether the agency does its work well. That is both a strength and a weakness, as we'll see in a moment. And last, you have to integrate this research function into your operations because that's going to give you good ideas about how you should be using your resources. In the modern economy, that's going to teach you what you need to know about tech. That's going to put you 10 steps ahead in understanding what's happening in the tech sphere so that you can pick good programs and ultimately pick good cases, and you build the capability to do that, and your judgment is respected because you are so proficient. You become, in short, one of the most important centers for microeconomic policy analysis in the country. In some respects, perhaps preeminent in some areas. This is a risky mandate. What makes it risky yesterday, today, and tomorrow? First, well, you've just been told you're going to do new things. The main area of your operation is establishing new standards. So that in every case you bring, the objection of defendants will be, this is unprecedented. The glib answer would be, get them straight. Design. That's what we were told to do. Don't you understand that? That's the norms creation function. Yes, you're right, but it's unprecedented. No one has done that before. We'll let them get away with it. It means that all of your efforts to extend doctrine will be challenged because they are something different and something new. And it puts, in a sense, a greater burden on your shoulders to show that those extensions make sense. Because there is nervousness about where you're going with this. You anticipate some of the objections made under the guise of the delegation, non-delegation doctrine about what you're doing. A second, because we've given you this broad mandate, comes the expectation that you can solve every problem that comes up. Food prices go up, you fix it. Gasoline prices go up, you fix it. Too much being charged for basic necessities, you fix it. And if you say there are a number of problems we can't solve, you are directed back by Congress to the language unfair methods of competition. Certainly that encompasses every possible source of bad behavior. Why don't you go fix it? Second problem is you're doing these novel things. Business people will argue that you are doing something new and you have extended it into areas that ought not to be pursued by your agency. You're doing things you shouldn't do. And you're arguing that's inherent in the mandate to stretch and to do new things. The affected firms come back to Congress and say, you did give them some authority, but not to do this. And Congress listens to that because they supply electoral resources in the forms of money and other support. So you have a virtuous cycle at work where the agency does novel things. Sometimes business complains to Congress. Congress comes back to the agency and says, why are you doing that? And the agency's answer is, that's part of our mandate. And Congress answers, we never anticipated that you'd do that. It's exactly how parents in the teenage years gave you the keys to the car and said, send me that wherever you want. And you go to the mall, and the neighbors see you at the mall, and they come back to the parents and say, I saw a bill at the mall, this fence. No, we didn't think about going to the mall. We thought about maybe going to the Dairy Queen a few blocks away. Bill gets hung, and they says, our parents, why did you go to the mall? The answer, you said, good answer you like. That's what we did. We went to the mall. The parents said, we never intended that you go to the mall. Maybe the Dairy Queen. But go to other interesting things again in the future. A doubting and cynical view of this is that this is a perpetual motion machine for legislators to raise money. Tell the agency, the agency does bad things, business complains, Congress says, not that one, but keep pressing the boundaries over time. Judicial suspicion, courts did not automatically say, my goodness, what a smart Federal Trade Commission. Especially guided by that guy Kovacic. He's really smart. He's an academic. Wow. Highest life form. Writing opinions. Certainly we're going to defer to his judgment because he's doing such a great job here. What do federal courts tend to think when they see members of administrative bodies before them? They look and smile and say, you can begin. What are they thinking? They're thinking if you were really smart, you'd be sitting up here with us. Instead, you're really a human. We are individuals up here. We are public figures. And we have the real conservatives of sensible policy making, especially a place like the DC Circuit, where they see administrative agency appeals all the time, with the agencies talking about their expertise, and they politely nod and say, yes, 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 please go ahead. But what are they thinking? We're the smart people who got the lifetime appointment. We have been touched by the hand of God. That's why we're here. And in front of us, we have administrative agencies. This isn't the Premier League. This is Division 2. But do go ahead. The deference has to be earned in a very serious way. It's not given automatically. The judges from the very start do not look at the FTC and say, my goodness, you are a powerful source of insight here. We are so happy to see you here before us. Next, the Department of Justice was not fond of having another agency in the competition space. Yes, in some ways, the FTC was a complementary agency that could do other things, including, in some times of its history, doing studies that were very useful to the Department of Justice in bringing its own cases. Thurman in the early 1940s makes a statement before a special congressional committee and says, give the FTC more money because these studies they're doing are really valuable to us. Thank you for that. So at times, the DOJ has welcomed that kind of special contribution by the agency. But the idea that you would have a parallel enforcement body using this administrative process with a broader mandate, not fond of that at all. Attorney General McReynolds tells President Wilson in 1912, 1913, 1914, do not approve this new legislation. We have a Department of Justice. We have an enforcement authority. We know what we're doing. Do not create this new thing. DOJ has become more polite about this over time, but when you peer into their soul and give them truth serum, they still think McReynolds was right. And they don't willingly accept the FTC's presence in this process because in many ways it is a substitute. If it really became proficient as this alternative dispute resolution mechanism, more business might go in that direction. And the FTC's role might expand in that way. And this unfair methods of competition, elastic mandate, in some ways might supplant the Sherman Act, which is what the Justice Department in many respects does, along with the Clayton Act. So the FTC's relationship with the department has always been a bit weird. That's not been a frictionless process. What's the implication? If this was an aircraft design, this would be called an unforgiving aircraft to fly. It means that the pilots that fly have to be really good because it's very temperamental. When the US built the U-2 surveillance aircraft, which flew in the 1950s over the Soviet Union, taking very good pictures, that was a very finicky airplane to fly. There was a 10-mile-per-hour window with which the pilot had to be very careful to make sure that the plane was flying at that speed within that 10-mile window for the long flight. That meant that for 7 or 8 hours, you had to be on the game, even with an autopilot that helped you out. This is a hard plane to fly. It requires very skillful navigation, very skillful choice of the course, very skillful management over time. It works if a lot of things go right. If things don't go right, neither does the airplane. What's been the historical evolution? This has been a scalable mandate. It's worked in some areas. The FTC migrated into becoming a consumer protection agency. It becomes basically the incubator for the creation of the Securities and Exchange Commission in the 1930s. It becomes, through its consumer protection mandate, which was unintended, but codified by Congress in 1938, becomes the data protection authority for the US. The side effect is that it has invited political intervention on a broad scale whenever the agency does something that I would say really hurts. And it's something new. That's where the argument and the concern about constraints on authority are magnified. And legislators at different times, sometimes they've codified new authority in the form of, again, the 1938 legislation that gave the FTC an explicit consumer protection mandate. But on other occasions, they've told the agency back off. And sometimes they've done it in a way that suggests don't go there again. And as a junior person at the FTC, 1979, 1980, 1981, a good part of my job at the time was dealing with incipient measures by Congress to take the FTC's competition mandate away from it. And the basis for doing it is you stretch too far. The agency's answer was somewhat plaintively, but you told us to. The answer was not that one. The lobbying efforts were very successful in getting the agency to back off. The agency really has to overcome that not having a really clear mandate to adopt substantive rules, not only the mandate to recovery of monetary penalties in certain areas, not to obtain divestiture in certain matters, certainly in Section 2-like cases, limited its scope of action significantly. The board expertise expectations, not fulfilled. I've put together those biographies over time. I have looked at the congressional heroic expectations about what the board would look like, and I look at the people appointed. The experience since 1970s has been a lot better. The notion that you have on the board, the range of backgrounds and skills that makes the board uniquely able to do good analysis in some areas, you can't make the case for the future of the commission on that. And why would you guess further that Congress overwhelmingly appoints people who have a deep connection to the legislature? As staffers, individual members of committees, they're handing out the jobs basically to people who work for them. Not just out of loyalty, but because I can trust these people to do what I want. they understand what we want up here. So they'll do that on our behalf. The current members of the Federal Trade Commission have spent a lot of time on Capitol Hill, including the chair, who worked for a year on a House committee, writing an important report for the committee. They like the idea of having people there they trust and believe in. That's not a formula for diversity in professional expertise. You have to be able to apply the research function on a regular basis. It means all the time you have an R&D agenda, doing studies that are linked to your sense of what the priorities ought to be. Sometimes achieved well, not consistently. And it means that over time, the norms creation function is diminished considerably, because over time, Congress starts giving the FTC independent litigating authority to go directly to federal court. And the key moment is 1973, where it tells the FTC, you can go to federal court to get injunctions to stop improper behavior on the consumer protection side and the competition side. That's where the agency tends to go to challenge mergers. If you took the pie chart of FTC litigation activity, say circa 1960, it's overwhelmingly loaded in the direction of administrative adjudication. If you took that same pie chart today, it's as though you pulled out the slice that dealt with administrative adjudication and you replaced it with federal court action. The agency overwhelmingly goes to federal court now. It means that the FTC is not using this distinctive capability that often. And part of the reason is that it knows is that courts are going to give the agency a hard time, not always. It's a bit of a struggle to get judicial acquiescence. Okay, strengths of the FTC, the research capability is good. In theory, the multi-purpose combination of functions can be useful. There's more attention to the agency in building out the professional staff to include more of these technical disciplines related to the digital market. With still weakness, it's hard to achieve policy integration across all these functions. The data protection, the competition, and the consumer protection functions in some ways have individual identities. I can recall the week that I became chair, I had a meeting with the head of the Bureau of Consumer Protection and her principal deputy, and I said it would help me a lot if you gave me the current workload, the Bureau of Consumer Protection. That is horrible Washington bureaucratese, meaning I just want a list of all the things you're working on. I want the Excel sheet, just print it out, one button, click, print it out. In unison, these two officials whom I'd known respectively for 30 and 20 years, these were friends as well as colleagues, in unison they said, why do you need that? And I thought to myself, Chairman of the Federal Trade Commission, need? My wish is your command. I don't have to tell you why I need it, I just do it. That would be a hierarchical approach. I've grown up in an academic environment, so I said, well, it would really help me understand the great work you do. So if you won't mind giving it to me, it took 3 months to get that document. It's as though I was trying to get a visa to visit North Korea. Instead, just trying to get the People's Republic of the Bureau of Consumer Protection to give me that document. Very hard over time to achieve a real synthesis of policy across these groups. Administrative adjudication has diminished dramatically over time. If there's a showdown over Humphrey's executor, that is the Supreme Court decision from 1935. It said the FTC's commissioners could only be removed for good cause. A key part of the Supreme Court's opinion in 1935 said, well, the FTC isn't a prosecutor. If it was a prosecutor, of course, it's a function for the executive branch, but they're not. They do administrative adjudication, so it's more like the court, and they do reports. For Congress, for others, there's no prosecutorial function being performed in the traditional sense. Of course, the president can't remove them. Today, the commission is overwhelmingly a prosecutorial body that brings most of its cases in federal court. Still limits on its remedies, creative efforts to extend them, but a lot of judicial resistance. Certain questions about whether it has the power to promulgate substantive competition rules, with the main focal point today being the rule that would prohibit non-compete clauses in employment contracts. And again, you look at the board, all lawyers today, always through Congress, no diversification across the board. So it's hard to go before a court and say, listen to us, because we bring a lot more perspectives to this than you do, Your Honor. It's ahead. Does this administrative adjudication power mean anything to the FTC? In the next decade, roughly, the FTC has brought a number of high-profile cases that challenge dominant firm misconduct. Qualcomm, over a decade ago. Syngenta, that's a case dealing with farm insecticides. Anesthesia Associates, a case involving a roll-up of anesthesia practices in Texas. The challenge to Meta's acquisition, basically, of Instagram and WhatsApp over a decade ago, and a major monopolization case involving Amazon, where they've all been brought in federal district court. If you're going to do the norms creation function and bring your special knowledge to bear on this, of course you'd be using your own mechanism, which was the basis why you were created. Brought in federal court. What does that tell you? Well, do you believe in it or not? And if your back's put against the wall and said, what are your distinctive recent contributions using this administrative adjudication process, the commission would have a very short list to offer. And this goes back to the Supreme Court on the question of your protection against removal except for good cause. The court's going to say, the agency we looked at in 1935 was an adjudication body, principally. Today, you're just another prosecutor. And of course, the president ought to be able to remove people, except for, even without cause. Last set of thoughts about the big challenges to the agency ahead. Are you going to integrate these functions that in theory would be a basis of superior insight? This is going to come up if this country gets an omnibus bill on privacy, which has been discussed for a couple of decades now. I suspect by the end of the century we will. At the moment, the question is, will we get a comprehensive privacy bill? If we do, that will be an occasion to think about where it goes. That would be about 400 additional people. And you can look at the FTC and say, okay, put it there, they're doing it already. But make them a consumer and privacy agency. Take this relatively lesser function on competition and give it to the Department of Justice. Congress expand the remedies, clear authority to get monetary recovery in federal court, as well as injunctive relief, to the Department of Justice and the FTC end up working together more to formulate policy and recognizing complementarities. Doesn't really happen so fast. They do work together on things like guidelines, but not on a whole lot of other things that involve their overlapping authority. Will they perform this advisory role to the courts? Watch to see if the Department of Justice ever invites the FTC to come to the party on the remedy proceedings in the Google case or the Apple case that DOJ is running. And last, is Congress ever going to deliver on the board diversification aims? That's so much within Congress's control. Will they put another economist on the board? Will they put an engineer on the board? And the judiciary seems minded to give administrative agencies a tough go ahead. It's Humphrey's executor, which I think will probably die in the next 5 years. The major questions doctrine that looks at whether or not your grant of authority is specific enough to do big things. That's probably the greatest threat to the survival of the FTC's non-compete rule. Is the Supreme Court going to look at this combination of prosecutorial and adjudication functions and say, that looks odd. You've got to have some separation there, much more than you have now. Is this unfair methods of competition really a delegation of legislative authority that is illegitimate? Can you do that? Did you basically tell the FTC, you can't figure out the rules right now, but you tell the FTC you redefine the law to address new circumstances? I'll just say that when you read the court's jurisprudence over the last 5 years or so, it is not a welcoming environment for broad grants of administrative authority. Environment for generous interpretations by an agency of its authority. That's a tough environment in which to sustain a model that relies so heavily on flexibility. So why keep the FTC in light of all of this? This is where my heart tugs me very hard in the direction of saying the agency ought to be continued, even though I think it is a moment of power for the existing framework. What do you want in the digital sphere? You probably want an agency that can bring multiple disciplines to bear on problem solving. And for all things digital, yes, that is competition, it is consumer protection, and it is data protection. You're going to decide what to do in a case like Google search. If you want to mandate access to data, you have to decide who gets access to how much data and how can they use it. That implicates privacy concerns from start to finish. Be nice to have an agency that's thinking about that as well. Research capacity, you've got to have the R&D capacity to be learning more. To have a specific mandate to go and get information and study new commercial developments so that you are 5 steps ahead instead of being 5 steps behind. It has to be agile and adaptable. It's got to be a scalable mandate. But you get specific commands in the statute, there will be circumvention. Nice to have a mandate that allows you to make adjustments using different policies tools, yes, including rulemaking, but certainly adjudication. And this is an unmistakable lesson from what the European Union has learned, I think, with the Digital Markets Act and what the United Kingdom is about to learn with the DMCC. So, if I get one more chance to support the FTC, I said, that's why this is a bad time to think about putting the competition mandate to sleep. That's why you want these functions bundled together in one place, because this is a moment where you might precisely want an institution that has those characteristics, but as I suggested, to make the assumptions on which this model was based work, there's a lot of work to be done in fulfilling those. And I'm not entirely sure in our framework of governance with 110 years, with not so much to show for it, I'm not sure that Congress is willing to do that in the future, but that's the case to keep the commission in the future. Thank you.
Professor.
Well, thank you, Avishalom, for inviting me, and Maria, and nice to see all of you. This is a really lovely campus and building, and I'm very happy to be here. And thank you to Bill for writing such an interesting paper that I get a chance to comment on. Bill's always traveling around the world, and landing in the same place as he is at the same time is actually low probability event. So thank you for arranging that, Avishalom. So every so often, interest in government efficiency becomes politically salient. And that might be happening again today, when one perennial question about government efficiency is whether we should have 2 federal enforcement agencies or just one. It's odd, though, we don't ever seem to ask that kind of question whether we should ask, do we need both a Marine Corps and an Army? And it's also odd that when the question of consolidation comes up in the antitrust agencies, we don't ever seem to ask whether all the civil enforcement should go to the FTC. The assumption is always that it goes to the Justice Department. The FTC always seems to be the target and not the model, which is some of what of Bill's point. And Bill's longstanding research interest in the design of antitrust enforcement institutions, means that there's no better guide than Bill to help us evaluate the future of the FTC when that issue comes up in the current push for government efficiency. Now, I came across this issue 30 years ago when I worked in the government. I saw it in the context of the Clinton administration's reinventing government effort, which was spearheaded by the then Vice President Gore. And I learned then that there would be little or no budget savings from moving the FTC's antitrust function, or all its functions, whatever, to the Justice Department, assuming that enforcement levels would be held constant. That was an important reason why the Clinton administration didn't push for consolidation of the 2 antitrust agencies. And at the time, I understood the importance for justifying the FTC's independence of one of the FTC's distinctive tools, namely administrative adjudication. the slow speed of administrative adjudication was a problem for those defending that agency in the mid 1990s. And it's one of the reasons why the FTC adopted procedural rule changes in 1996 to speed administrative trials. But the FTC, of course, has other distinctive tools aside from administrative adjudication that Bill's paper, which I don't know if you've seen the paper, but I've seen the draft, that the paper highlights. Those tools were not prominent on my radar when I worked at the FTC in the mid-1990s. This is when I was the bureau director. The Bureau of Economics was in charge of competition advocacy then, but meaning the function where you give advice to state legislatures, other government agencies, federal agencies about how to perform their functions with competition in mind. The Bureau of Economics was in charge of that then. I don't think anymore, but couldn't do much of it. Not because we didn't want to, but because we couldn't spare many people for that project in the middle of a merger wave that was straining agency resources. And the Bureau of Economics also issued a couple industry studies, but again, we couldn't devote many resources to that work. I don't recall the FTC conducting any studies using a power it has under the FTC Act to subpoena power to collect information from industry in order to write reports. Though the FTC, when I was there, did have extensive hearings on antitrust policy issues that led to, among other things, the 1997 revisions to the merger guidelines on efficiencies. And I also don't recall thinking hard about exploiting synergies between the antitrust and consumer protection missions, including, what were then emerging privacy issues. The FTC didn't consider undertaking competition rulemaking. Although I had personally, written an article not that long before that, suggesting using competition rulemaking to address unilateral facilitating practices like those the agency wasn't able to reach in a case called Ethel involving DuPont, about most favored nations that were, clauses and some other things that were unilaterally adopted by the four firms in a market. Bill's paper does a terrific job of laying out the features that distinguish the FTC's antitrust enforcement capabilities from the Justice Department's capabilities, and explaining their origins and their history and defending them on policy grounds. But the paper doesn't say much about some perennial arguments for institutional reform that aren't partisan. One's whether there's a practical difference for merging firms depending on whether the FTC or the Justice Department reviews their deal, given that the Justice Department typically combines preliminary and permanent injunction trials in a single proceeding, while the FTC doesn't necessarily do that. And there's also a related issue of whether there's a practical difference in the statutory standards for awarding a preliminary injunction in a DOJ and FTC case. And the merging firms hate delays in review that might arise from clearance disputes, which is the process where the two agencies decide which one should look at a particular transaction. Is it in the Justice Department's wheelhouse or the FTC's who want to get it? And arguing about that sometimes delays the merger review substantially. Well, Bill's paper is clear and interesting and convincing in discussing the FTC's features and functions and the legal and political constraints on its actions. And it shows there's a lot useful to say in looking at FTC reform from the perspective that emphasizes the value of effective government administration. And that's a perspective that puts aside contemporary partisan debates. Now, even there's a debate today about the present debate about the role of the FTC in antitrust does have strong partisan overtones, but it's still valuable to point out that the protection and promotion of competition is widely accepted as an important goal, and that the FTC has some antitrust enforcement capabilities that the Justice Department does not. That means that there'd be a cost to moving the FTC's antitrust enforcement activity to the Justice Department. Either you give up the FTC's unique capabilities, and that makes antitrust enforcement less effective, or else you have to replicate those capabilities at the Justice Department. And that creates an opportunity cost for a Congress that has other important tasks to go and figure that out. And it imposes substantial setup costs on the Justice Department. Now, the costs involved in moving the FTC functions to the Justice Department could potentially persuade an FTC skeptic who cares about competition that a major government restructuring to redistribute FTC's functions to the Justice Department is not a high priority, and it could give some cover to a legislator whose political base has mixed views about the FTC. Not to sign on to targeting the FTC for serious reform. And so for those reasons, the paper might usefully discuss more explicitly the costs of giving up or reallocating FTC's distinctive capabilities. But to make its argument about government efficiency, Bill's paper downplays partisan aspects of FTC reform. And I can't fault that choice. But add that it might be hard to sell a nonpartisan government administration analysis that focuses on FTC capabilities today. That's because during the Biden administration, the FTC did something that none of its modern predecessors attempted, which is it systematically attempted to revive the toolkit of distinctive FTC features for antitrust enforcement. The FTC didn't, not everything, the FTC didn't ramp up administrative adjudication during the past 4 years, which Bill emphasized, but it engaged in competition rulemaking. It issued studies using that subpoena power under the FTC Act of industry conduct. It employed competition advocacy as part of a whole of government approach to competition policy. And it sought to establish that Section 5 unfair methods of competition extended well beyond the Sherman and Clayton Act, not just to invitations to collude. The Sherman Act doesn't reaches attempted monopolization, but not attempted price fixing, say. Section 5 of the FTC Act would reach attempted price fixing, and it's well established in a bipartisan way over decades that the FTC, the FTC has its authority. It's been unchallenged really for a long time. The paper doesn't talk much, if any, about these, and so the current FTC tried to go farther than that. The paper doesn't talk much at all about these Biden-era FTC efforts specifically, even though they could be understood from a government administration perspective as illustrating the value of the tools the FTC has and the Justice Department does not. And so why does it downplay this effort? Well, that's presumably because the Biden-era Federal Trade Commission became a partisan lightning rod. Anything Lina Khan did was almost automatically embraced by cheerleaders outside the agency and viewed with suspicion by critics. Some of the Biden FTC's efforts to revive the FTC's toolkit were controversial. Within the agency, they split the commissioners on partisan lines, and they have an uncertain future in court, which undercuts their utility in demonstrating the need for an independent Federal Trade Commission. And I'm thinking particularly about competition rulemaking and the statement the FTC issued trying to explain what would count as an unfair method of competition under Section 5 that would go beyond the Sherman Act, the Clayton Act, the major antitrust statutes. Even though there are good reasons for the paper to stay away from what the current FTC has done, I worry that conspicuously avoiding these initiatives could detract from the paper's credibility. And the issue of partisanship is larger than the divisive role of Lina Khan. It's about antitrust enforcement more generally. The paper implicitly assumes that antitrust enforcement pursues a broadly shared competition goal. When there are partisan shifts, it's like moving the football from one 40-yard line to the other, with the Democrats slightly more interventionist. And that's generally a good model for the past 80 years, really, even recognizing the way the courts reshaped the antitrust laws in the 1980s. If there's a reasonable consensus on the goals of antitrust enforcement, then you can look to institutional design, which plays the role of identifying the most cost-effective way to achieve them. Maybe conditional on some legal constraints, the due process, separation of powers, that sort of thing. And that's what I just described as the implicit perspective of Bill's paper. But what if the goal of institutional reformers isn't to promote competition in the most cost-effective way? So I'll conclude, I'll just try out a couple possibilities. First, suppose the point of institutional reform for its advocates is to increase executive branch control of antitrust enforcement. Now, some people might want to do that because they have doubts about the legitimacy of, or the constitutionality of integrating prosecutorial and adjudicative functions in a single agency. Or they have doubts about the legitimacy of independent agencies generally because of limited executive branch control. And other people might want to increase executive branch control to make antitrust enforcement more responsive to the president's policy concerns, even if they don't question the legitimacy of agency structure. And it's true that the Congress and the courts sometimes have different views than the executive branch about which branch of government should control antitrust enforcement agencies. And Congress has been involved a lot with the FTC, and the current Supreme Court is not shy about taking power to itself. But still, government power has often shifted to the executive branch in past decades, and it's possible that the new president would have the political capital to promote a continuation of that trend in this area. Now, one danger of increased executive branch control of antitrust enforcement is that it facilitates political misuse of the antitrust laws by a president that wants to influence decisions in order to advance his own political or financial interests. Now, my guess is if Professor Alford were here, he would say that didn't happen at the Justice Department during the first Trump administration, despite some accusations along those lines. Maybe institutional reform advocates aren't worried about that now, but there is likely a partisan divide on that question. And in any case, I think the argument for insulating government functions from direct political control is stronger for the Federal Reserve, say, than for antitrust enforcement. So let me give that for the second alternative, possibility for institutional reform, the point of institutional reform other than just promoting competition in the most cost-effective way. Suppose the point of institutional reform is to limit antitrust enforcement by just hobbling the federal enforcement agencies, the institutions. Some people might say that Biden administration antitrust no longer operates between the 40-yard lines, and that anti-monopoly activism by the Biden FTC threatened big business interests and prompted a big reaction from them. And on that theory, institutional reform serves the big business interests that want less enforcement. Now, that might seem inconsistent with the president-elect's statement nominating a new Assistant Attorney General for Antitrust, which calls for continued antitrust enforcement against large technology corporations. But even for big tech firms, institutional upheaval could delay new investigations and provide opportunities for settlement on terms more advantageous to the defendants. Now, I don't ultimately find this second suggestion convincing because institutional reform is a cumbersome way to defang the FTC. It's much easier to get the FTC to change course by appointing a new chair and, assuming Lina Khan resigns, appointing a new commissioner. And in any case, the Supreme Court's likely to limit agency powers as a byproduct of its broad attack on administrative agencies. Bill doesn't get into any of these partisan issues in his paper. And I'm not suggesting that he should, but he might want to say more explicitly that there are easier ways to curb the FTC than to shift its function to other agencies. So ultimately, Bill's paper can be thought of as an effort to dampen partisanship in the institutional reform debate. But I still worry that political polarization and partisanship makes it hard to persuade people by relying simply on good government arguments about administrative efficiency and effectiveness, no matter how well those arguments are presented as Bill's paper does. So thanks.
Professor Baker, we're going to have Professor Maciá's comment, and then we're going to move to our roundtable.
I'll try to keep this on the brief side in the interest of time. So I guess I should say, the expectation would be that I would push back on this, because my only experience working in government on antitrust was actually for Department of Justice. So I'm probably maybe one of the most optimistic people. And I did not receive the job offer to come here as to do a VAP, be a visiting assistant professor at Notre Dame. My plan was to go apply to work at the Department of Justice. So I'm a big fan of Department of Justice. Ultimately, I agree that the FTC plays an important role. And in fact, I think I want to highlight, I think I generally agree with Bill that there is a lot of potential that's being underused, but I want to highlight the way in which that potential is being used and how that is better than the alternative of getting rid of it. So the three areas I'm going to focus on are expertise, reports, and rulemaking. And then I'm going to talk a little bit about like potential inefficiencies, why I think that it's not the case that the clearance process is a problem with the with the overlapping opportunities to review mergers, and then also maybe one way in which we might scale back the FTC a little bit to save on government costs. Okay, so I think so Bill's paper really focuses a lot on the value of expertise here, and I think that that's very important because I do think that I would agree that is something that is central in antitrust. So I've been doing work on thinking about specialist antitrust courts and looking at other countries, and there are many other countries where they do really try to bring in these experts. So Chile, South Africa, the UK, these are countries that have recently reformed their antitrust adjudication process to make sure that economists are involved in the process. And this makes a lot of sense because antitrust, if we're trying to think about what is going to be the effect on consumer welfare, that's an empirical question that requires an understanding of markets that's complex. And so including economists at the table in thinking about that is important. So in that sense, the numbers that were presented about the number of economists that were involved are depressing, but if you cut the data in different stages, it is a little bit, I think it provides more room for optimism. So I looked at your first paper where you sort of examine this, and if you look at the period between 1980 and 1997, 5 of the 13 commissioners were non-lawyers. So this was maybe we can say this is a golden age for expertise on the FTC. And maybe we need it instead of saying that. And so 3 of them were economists, but 2 of them were people with outside backgrounds that do add a lot to sort of understanding about technology and industry. And so maybe the question should be, what was going on during that time period that made that possible, and what can we do to make that trend continue? I think since it must be the case that since 1997, there only has been 1 economist. So something had changed in 1997. But again, thinking back to that time period might be helpful of thinking about, okay, what can be the path forward for recapturing this role of bringing experts in. The other thing that I think that's special about the FTC, if you compare it to the Department of Justice, is the role of the Bureau of Economics within the FTC. So my understanding is that in the FTC, the Bureau of Economics provides independent recommendations, and this is actually very interesting because for scholars, because I think you can look at what were the recommendations for the Bureau of Economics compared to the Bureau of Competition, which is mainly lawyers who are coming up with thinking about mergers. And there are different recommendations, and they often make different arguments. So one thing that I think is very striking is that if you look at so this was Malcolm Coate, the former director of the Bureau of Economics, in 2009 put together a paper where he looked at the recommendations that were made by the Bureau of Economics on mergers compared to the Bureau of Competition. And he found that the Bureau of Economics was twice as likely to consider efficiencies as the Bureau of Competition. And so there's this idea that economists might be looking at slightly different things. And efficiencies, I think, are especially important to to consider in merger analysis, because we're asking, even if competition is if the amount of concentration is increasing, is there going to be an opportunity to lower costs and pass those through to consumers? And at a time where we're very concerned about inflation, that seems particularly relevant. And so I think just the structure where there's a Bureau of Economics making independent recommendations is something that's very important about the FTC. That's different from the Department of Justice. So the Department of Justice has what used to be called an economic analysis group. They recently changed, the name was changed to the expert analysis group. So I think this almost says something about like the downgrading of the role of economists in the Department of Justice. And they're involved, but they're not always making these independent recommendations. So I think that that's a really important difference between the two that should be capitalized on. And then, so I think I'm in complete agreement about the value of adjudication through the FTC. So my preference would be to have a specialized district court, but given that we don't have that, administrative law judges have the opportunity to hear multiple antitrust cases and to learn through that process of doing that. In the area of patents and bankruptcy and criminal law, there's substantial evidence that when judges have a chance to hear multiple cases, they get better at doing that judging. And I think that this has been an under-examined area. So there's really only been one area that has tried to, or one article that's tried to compare the success of administrative law judges at the FTC in comparison to district court judges. And this article, it's an article, Angela Dively and Joshua Wright wrote it. And the main way they look at whether those courts are doing, the judges are doing better, is they're looking at reversal rates and whether parties appeal. And they find that parties are more likely to appeal from administrative law judges, and those decisions are more likely to be reversed. And so they take this as evidence that administrative law judges aren't really doing any better than sort of like the specialist district judges. But I think that this study it's not necessarily, we shouldn't make that inference doesn't necessarily follow from the data, because there's a key difference between these two types of judges and the process. So if you are appealing from a district court judge, you don't have a choice of which appellate court you're going to appeal in. Whereas if you're appealing from an administrative law judge decision, the parties get to choose where they're going to file that appeal. And so they look for places that are more favorable to file those appeals. So one would expect the option value of appealing is higher because you get to sort of do this forum selection. And it's also the case that you are going to be more likely to be reversed because you've handpicked the appellate circuit in which you're going to have the best outcome. So I think that that the promise of administrative law judges in the absence of specialized courts is something that's incredibly important. Okay, I didn't want to take too much time, so I just want to talk briefly about reports, because I don't think we've heard a story of the FTC doing, like, following in on that research and reporting requirement in a positive way. And so I want to highlight one thing that the FTC is working on. Again, I think they can work, they can develop this more. They've made progress in this, which is the FTC has a role in trying to foster retrospective merger analyses. And so the idea behind a retrospective merger analysis is that after you let a merger go through, or if you block a merger, you look at, okay, how did the market react? Like, what happened to these companies? Do they actually raise prices? And this is an understudied area. There are not many articles that look at this, in part perhaps because of data problems. So their academics are interested in this, but they don't necessarily have the data. And so again, this is the FTC has access to this data. They could make this part of a consent decree when they allow a merger to go through, that there's like continuing provisions of data requirements. And they've increased their roles in this. So if you look on their website, they don't have any studies published. But it's clear that they are monitoring this area, and that they are, it says they plan to dedicate more time and resources to retrospective projects. So this is an incredibly important area for us to think about for figuring out whether we're getting our merger policy right, and the FTC can play an important role in that. I also want to talk about rulemaking, and I think I generally agree, and I just want to say that I think rulemaking is especially important when we're thinking about economies of scale in big tech. Because the idea is that with rulemaking, the FTC is going to be able to go beyond some of the traditional Sherman and Clayton actions that it could take, and it would be able to sort of identify incipient monopolies, even if they might not meet the standards of conduct that is anti-competitive under under the Sherman Act or the Clayton Act. And this to me seems, so I think the non-compete agreement is a good example of why this is so important in the context of thinking about big tech. So if you, the non-compete rule says, goes very far. It applies to all industries, but we can definitely imagine some industries where this is incredibly important. Take AI, for example, where a lot of what's going on in AI is companies are fighting over talent. And so it may be the case that if you can block your competitors from being able to hire talent, that is going to give you huge resources in this and allow you to sort of like to block out competition. So these are examples where it may not be the case that a traditional Sherman or Clayton Act would get you anywhere on those, but you could make a clear rule that is going to address this problem and not take all the time that litigation would take. So that's the other benefit of rulemaking. It sets clear rules for industry players in a way that doesn't require the time of litigation, which we might not have. So that was my pitch for why rulemaking, I think, is very important here. The last thing I'll say is just on the clearance process. We've talked about this a little bit, and I think this is an area where it looks like, okay, this looks like an inefficiency in government, where we have two agencies that could be overlapping and they're dividing up these mergers among themselves. So if you look at the data, so the GAO did a Government Accountability Office did a study where they looked at all the situations where the DOJ and FTC were dividing up mergers between themselves. And they looked at like the years 2016 to 2020. And in 4 of those 5 years, there were less than 1% of transactions reported where they went through this contested clearance process. So in the vast majority of merger cases, this system works. They're divided up evenly between, they're divided up in a non-contested way between these two agencies. And in the cases where there is potentially dual and where they're both fighting to be involved, this may be a situation that actually works well if we're concerned about under-enforcement of these agencies, because you basically have think about it as two independent agencies that are checking to think about whether there's going to be a problem here. And so having 2 pairs of eyes might be better for not missing something. And given the costs of allowing companies to merge when those companies are ultimately going to become a monopoly are so high, it may be a very cheap cost to pay for that, just having 2 agencies doing that. So I think the issue about the clearance process is sort of overblown. And if you do want to find one area in the FTC to cut back on, some people have called for possibly shrinking the Office of International Affairs. So this is where the FTC sort of coordinating with other international global antitrust agencies, and it might make sense to say that is more expressing what the U.S.'s policy is, and having someone who's an agent of the executive would be better suited to do that rather than an independent agency. But that's otherwise, I think that the FTC plays an important role, and I hope that the current scrutiny of it will only encourage it to do a better job on its potential rather than leading to it being cut. Thank you.
We are going to continue here, and I would like to start as we sit down with giving Professor Kovacic a chance to reply to any selected things. Obviously, we're not going to address all the issues, but if there's anything, Steve, please.
Thanks to John, Maria. Thank you so much for enormously helpful comments, and I'm grateful for the evident thought and care that you put into this, and this will be very helpful for me. And you'll get another edition of this. So thank you both very much. Not everyone here might fully understand what it takes to provide good comments, but I do, and I'm grateful. So thank you. And I do on John's one of John's larger points. I think I do have to address the political context and the nature of the debate, and to deal with the specific arguments that have been raised about the agency's work, but also to address how recent developments have drawn attention to different features of the agency framework, and maybe to offer a few more thoughts about solutions or responses to some of those objections. And that I certainly intend to add. That's a crucial bit of context. And Maria, these are great suggestions. I'll go back and take I mean, it's an interesting question why there was a period when the diversification of expertise on the board increased in some ways, and why that went away. Why can that be restored? I can say a hard question in the background is, would Congress ever be minded to restore it, given their aims? Both the White House and the Congress, would they do it? Certainly to explain more, to think more about, as both of you are suggesting, what do you lose if you give this up? What do you lose from the giving up the FTC's existing configuration? No doubt that a greater investment in evaluating outcomes would be really welcome, I think, in this area. A question that's asked of antitrust law all the time is, does it work, and how do you know? Show me the results, and especially building a strong inventory of insights about past remedies and effectiveness is indispensable to informing judgments about remedies in merger and non-merger cases in the future. That would be a very valuable effort. A difficulty is that historically that doesn't generate observable policy results today. And you need a norm that says those kinds of investments in longer term policy improvement are worthwhile. Washington is not an environment that encourages that kind of thinking, and how to persuade people that by making those investments, your future work is going to get to be a lot better. Just mention one thing that's hard for me to deal with here, and it is part of the modern environment. An approach taken by not just by the Biden administration, but in earlier jurisdictions. There's a great difficulty in building norms that identify what good practice would be over time. Two chairs that I admired a great deal, learned a lot from, are Bob Potofsky and Tim Muris. I think Bob and Tim are two of the only people in the history of the agency who understood what the agency's possibilities were, understood the importance of formulating a program to use those possibilities, and deliberately sought to steer the agency in the direction of doing those things. I mean, John mentioned a number of things that Bob did. Potofsky and Muris did I guess what could be called a duet in 2005 that published in the Antitrust Law Journal, that expressed their views about what the high ground for the agency's work had been. These are two people who did not, of course, have absolutely identical thoughts about what policy should be, but there was an astonishing degree of similarity about their thoughts about what the agencies had to do to be effective, and what they had done, and their own view about where the agency had realized potential. That is a vision that the Biden team rejected. You don't see the Biden team. What's so Jonathan Cantor? Jonathan Cantor was a junior case handler at the FTC in an earlier age. Doha Mekki worked at the division in the front office for the past 10 years. I've much more heard Jonathan, David Lawrence, these are senior officials in the Justice Department, Doha Mekki say, I'll be damned if I'm going to ridicule the period of service I had before and say it was a barren and useless period of service. They won't do it. not so much for the FTC, but even Jonathan and his front office, not so adept at looking back at past experience and saying, you know, we have a new program, we have our views, but here are foundations we are building on, and our program wouldn't work unless these other foundations were in place. That makes it really hard to build norms over time. And a point that the Biden administration team made, and its advocates on the outside, and Elizabeth Warren and the president himself, was, I'm inheriting a long period of failure here. We're going to do it better. I never heard President Biden in any of his comments say, well, by the way, I was part of that 40 years of failure. I was the vice president for 8 years. What the hell was I doing then? But beyond that, to say, you know, here are specific things done by the agencies before. In rolling out his whole of government approach, in the whole statement, I never heard the vice president say, here are antecedents within the agency's practice that are directly supportive of what I'm doing here. I'm broadening that footprint, but good things were done before. I think what public administration scholars tell us is that successful policy development is cumulative, that you have big jumps at times, but you have an accumulation of effort. The Biden team rarely, if ever, acknowledged that, and its supporters on the outside would not speak well of it. I mean, Rohit Chopra, who was the commissioner, you know, after wasn't there at the time Rohit was there, but Rohit gave a speech over a year ago and said, when I got to the FTC in 2017, the FTC had descended into deep decay and disarray. None of the incumbent commissioners gave a talk and said, what you just heard is nonsense. That's not right. Here are good things that had happened before. So the narrative, and by the way, I'd seen this movie before when I was a junior case handler at the FTC. I lived through the transition from 80 to 81, which was rough. And there again, the new leadership did not look back at what happened and said, I'm changing things, but there are good things as part of that program, and I'm going to acknowledge those things. If you have a cycle of public administration, which you have these periodic efforts to say, everything you know is wrong, everything you know is wrong, catastrophe, I'm here to fix it, that's not a good environment for building effective programs over time. And it's a sad part of our public administration. We don't have that. So I don't even, given what Chair Conklin and her colleagues have said and their fan base on the outside have said, I don't know that you could go to one of their conferences and give a speech and say, we'll just pick Democrats, the Petoskey program was a good vision of what the agency could do. I think that team would say that was a period of timidity and cowardice, and the only people who really think they did a good job there were Bob and his team.
But how does that bear on whether the functions ought to go to the Justice Department or stay at the FTC?
Just whether the FTC is doing a good job, you know, you want to keep do you keep the FTC together indirectly, supported by saying they're doing a good job there? And you know, Bob and Tim and their duet spoke a lot about why you want this combination of functions and principle together. I don't know how you build the consensus going ahead, how you address the polarization now, if a starting point is that public administration in this earlier period was completely bankrupt. And that's a hard narrative to overcome here.
Anybody wants to react to you? Okay, so let me just kind of push forward on the main theme, Bill, if you're talking, I'd like to hear what everybody's thinking. I mean, you make a pretty impassioned and persuasive case, and I see the connection. And to try to play and try to play the devil's advocate a little bit.
So the devil has so many people working for him. It's the biggest damn law firm in the world.
So yeah, but I'll still try to push against.
Yeah. Okay.
So here's so the best case that you're telling is the FTC has this package of potential capacities and capabilities and functions that may provide sort of a unique package with some value that is not, say, provided by DOJ on the antitrust front. I can hear that story, but part of the problem is that even in the best telling of that story, there is no, at least realistic universe, I think, going forward, right, and it's been mentioned before, where the FTC gets all of, say, civil antitrust enforcement because of that combination. And
Yeah.
so that option is kind of off the table. There is always going to be a very large part, or even a larger part of antitrust enforcement that is going to happen with the constraints and function, the nature of the game as it happens within a procedural setting in DOJ, which is, you know, with the differences that we're saying. So if you do take that as sort of an unavoidable reality, whatever, you know, alternative universe might have existed, does the case for, yes, maybe retaining the FTC, but with, you know, much more expert education, much more building expertise, much more R&D, much more kind of between a regulator and an adjudicator, but not a prosecutor. What kind of survives the case of leaving the FTC in that world with, you know, the standard sort of merger enforcement or the civil cases or all the stuff that's now happening right in courts? You know, what's the counter argument?
I think John pointed to it in some ways before, and it's also suggested in Maria's comments. An important thing that I have to build in here is here are examples of good work done previously. This is here is how policy advanced, how doctrine advanced because these tools were used. And to answer this point, Avi, to say, you know, here's what you're giving up if you don't have the FTC engaged here. You don't have a case like the Hospital Corp merger decision from the 1980s, which was an important contribution to thinking about coordinated effects. Here are administrative cases that made it different. You know, our colleague Andy Gavel is very fond of McWane as a case that moved things ahead. What Andy calls small cases that make big law, cited over a dozen times by Judge Mehta in the Google search case. To come up with a list of things that were done when the agency worked arguably as intended, and how did that happen? Can that be replicated on a larger scale? So I think what I have to lay out here is, you know, here's almost in the style of It's a Wonderful Life. Here's what you give up if the FTC isn't there. Here's what happens in the policymaking world if you take it away. By trying to come up with that list, I suppose an observer might say, boy, that's thin. And in some ways it is, compared to what perhaps it ought to have been able to do. But, you know, one area that I think globally commentators say, you know, deserves attention is where you have artificial public barriers to competition. The FTC, really since cases like professional engineers, the FTC sort of led that charge over time to pare that back, doing advocacy, writing reports. So I think an answer to this has to come from an effort to say, here are the good things that came from the use of these distinctive tools. And part of my pitch would be, you know, competition rulemaking authority specifically articulated would be a big help to the agency's work in the future. I'd put that in there. I don't have a good answer to all of your larger questions. And Avi, your point now, you know, could you get Congress to make the additions that I would say would be very useful, if not necessary, to realize the fuller vision? Would you ever get monetary recoveries for violations of Competition Consumer Acts? Would you ever get Congress to provide rulemaking authority? Maybe in the new regime you could. I've been to events where I've senior legislators in Chatham House settings who I can't identify specifically, but said things such as long as Lena Khan is the chair, they're not going to get a single bit of new authority. You know, I just won't do it. I'll see who else is there, but it does have a stable equilibrium for the future. We'll give you a withdrawal authority depending on who's in the leadership position. I don't know that some of the things I would be asking for would be provided, but I think you have, at minimum, have to say here is the greatest hits playlist that one has to study, especially in the modern era, And this is what you lose if you toss this aside, as well as here are the things you could get if you used it, as Maria was saying, you made better use of what you have.
Okay, great. So I think John started pushing a little bit of a connection between the historical arc and the big questions. Sort of a concrete moment in your answer now sort of talks to that a little bit. How much do you guys think that of what we're seeing now is really another reflection of that historical arc, and how much of it really this moment is a little different with the build-up? And I think some of it was described sort of implicitly and likely, I think, in John's thing, but there has been a lot of upheaval inside the FTC, a lot of and some of it can be chalked off to, you know, to style of management and things like that, but some of it is more fundamental, right? It's kind of the notion of having that we lived with for quite a number of years, kind of an accepted core and understanding of what antitrust is about, and sort of almost the end of it, kind of, it's another one of those moments when you think it's kind of the end of history for a field and you just wait a couple of years and everything is different, so, right? But that's kind of part of what animates the life, the internal life of how people think about within an administrative agency. And if people, like, you know, just take a concrete example, sort of the role of consumer welfare, whether it's general or as a merger screen, you know, as opposed to taking other considerations and so forth. And we have fundamental disagreements on that. You know, is it really this moment is different because we have sort of these new, very strong fault lines that are posing these tensions in a way that maybe we've had historically, but not for a very long while. What do you think, John?
So if there's a, turn this on?
I think they're on. I think they're all on.
Okay, it's fine. You can probably hear me anyway. If there's something unique about this historical moment, I don't think it's actually the anti-monopoly activists, the neo-Brandeisians at the head of the agencies. However the Trump administration decides to fill the FTC chair spot, and then they've not announced a potential prospective Assistant Attorney General for Antitrust at the Justice Department. Those two will have to kind of end up being on the same page in how they think about goals of antitrust, more or less, and then they'll have an institutional interest in defending that, and there won't be a reason to want to defang the FTC anymore. If there's something unique about the historical environment today, I think it's actually the administrative law changes that Bill was talking about. You know, major questions, Chevron deference, and prosecutor and adjudication in the same agency, and all of those issues being teed up at the same time, which are generally concerns about administration agencies across the board, not about antitrust.
No, so just to take it a little bit of an angle, and I hear what you're saying. Let me give another concrete example. Sort of when you think about merger guidelines as one of kind of an important way which historically, since I don't know the mid-80s, right, we have had increasingly influential kind of policy promulgation from agencies that does not have any binding force officially on the courts. And as the years go by with increasing iterations, 92, 97, 2010, you know, we see those early 2000s merger cases, Staples, HR Block, doesn't matter those cases. You see those judges literally, you know, saying we're not bound by the guidelines, and then proceeding to simply work through the guideline in the most methodical fashion possible, as if it is the most compelling story that they need to follow. And that was a trend. It was a trend that increased for quite a number of decades. Then we get to more recent times, so we get to other kinds of guidelines that got less attention, or things that got pulled back, like the Section 2 story that we had in the early 2010s. Now we had relatively new vertical merger guidelines in 2020, right? That then, you know, got pulled back, and we have the new merger guidelines in 2023 that changed a number of things we don't have time to discuss, but both in content and in style, in the way of presentation. I'm sure there were some good things done there, but I completely see a possibility of a new administration coming in, no matter if they even agree with 90% of the substance or 95%, pulling back the guidelines and installing the old ones, all this kind of dynamic in terms of when you think, again, the context of Bill's talk, what does it do to the perception, whether it's, on Capitol Hill, whether it's in the courts, whether it's the public, or people who even care, they have to be sufficiently informed, about, the agency, the expertise, what is going on here. So
I can give you my thought about why you shouldn't just bring out the same rubbish bin into which you threw the 2020 vertical guidelines, that you should not, that you should be careful about those kinds of abrupt moves. If I were advising Gail Slater and the head of the FTC, I'd say, you don't want to just withdraw them and pitch them out right away. You want a different process. Why? My sense of a system in which you must appear in front of judges on a regular basis forces you to think about what gives respect to your decisions. What do judges look at and listen to as a basis for giving you the benefit of the doubt? In a post-Chevron world, I guess we can't say deference, but let's just say respect. That goes back to predecessor decisions involving interpretations of agency authority. I mean, what are you doing in front of judges when you appear in front of judges? Ultimately, you're saying, whether it's an appeal from an FTC decision or in front of a district court, you're saying, trust me. That is, there are contested facts here. This is my interpretation, but especially in an FTC adjudication appeal. Trust me, because I'm going to demand my good professional judgment to the resolution of this problem. I've done my homework. I've done the studies. I've done reports. I've done the analysis. I've got the quality control inside the agency that comes, for example, from having the Bureau of Economics. I've thought about this in a way that not only looks at the technical issues before me, but I have the combination of expertise and experience that gives me something we call intuition. And that intuition is worthy of respect here because of what I brought to the picture. I know the judges will not always agree with me, but that's ultimately what I'm trying to persuade them is the basis for what I'm doing. In that context, I don't want to do things that look erratic, that look impulsive. That is, to spend basically a year now successfully in cases like Tapestry, Capri, saying, my guidelines make a lot of sense. I want you to absorb some of them, but then to come in and say, those guidelines are rushed, and we're reverting back to something else I did before. If I'm a judge and I say, well, what are you going to do 2 years from now, 3 years from now? That is, you are completely moved, it seems, by electoral outcomes. There's no inherent stability in your decision-making process that points you in a certain direction. The things that are poison to getting this kind of respect are the sense that you're a drunk driver swerving across the road, or that what's going on is you are simply beholden to specific political impulses and pressure. Judges have no reason to defer to extortion or pressure. They might defer or give respect to good professional judgment. So if I were the personal trainer for the heads of the agencies, on the guidelines point, I'd say the agencies already didn't do a great job putting those together. There were real avoidable errors in the way that was assembled, knowing how hard it is for two agencies to agree on coming up with that. Still, there's something there that's worth keeping. Don't throw it out simply as an impulsive move. Say, we're going to look at this. We're going to think of this. Maybe you have the guidelines after 1 year. The first anniversary comes up in 2 weeks of that document. We're going to say, how are we doing after you? We'll have a public consultation. We'll think about this. Maybe we'll do refinements. But I would strongly advise against simply saying this goes in the basket right away. No impulsive moves, good professional judgment that you're offering to the courts. I wouldn't want to be walking to the courts now, somebody saying, oh, you're right. Those guidelines, we've said it in our briefs, and there are a bunch of these. It's Templar, it's the mattress case, it's corporate nonsense. I don't want to be going into the court saying, Your Honor, sorry, we just threw those out. So don't rely on that. And maybe in another year or so, we'll have something else there for people to look at. I don't like that kind of visible instability. I want something that's more measured and thoughtful.
I think that makes a lot of sense as a strategic matter, especially when you consider that the move of the guidelines was to sort of to allow more enforcement, right? Like situations that would have been adding more cases, taking cases out of the safe harbor, and making things that might have been a close call, signaling that, oh, we're not going to treat these like a close call. And so you could change, you could still shift your enforcement policy while leaving those in place. And that's, I think you're right, for like the credibility of the institution. There's a little bit of tension there with predictability, right? Like I think there's a problem if what the guidelines say about how we're going to be treating mergers and we're going to be treating mergers much more, scrutinizing them much more carefully, it might chill some mergers from happening. And so I think that there's going to have to be an art to, like, if you're going to, for strategic reasons, leave the guidelines in place, you need to do something to get predictability back to, like, so people know what your actual practice of enforcement is.
One of the reasons the guidelines have been influential is, the agencies are setting out a framework that they're going to use to think about cases that's independent of any case in front of them that they plan to use going forward. And so it looks like an effort to figure out what's the right analysis. And the courts don't, at least haven't historically done a lot of merger cases. There's some, but so they don't think they have expertise, and so it's a technical area for generalist judges, and so they look to the agencies and the guidelines. And in addition, and this isn't anything that differentiates the Justice Department and the Federal Trade Commission, because these are all jointly since 1992 they've been jointly issued, most basically. So I don't view this as an issue for the big question in Bill's paper about what to do with the FTC. I would but my only comment is that some of the thing that strikes me as the most controversial change in the general framework of the guidelines is how much more legal they became. Since from between 2010 and 2023, and they put in cases, the case law. They try to explain the courts something the courts are experts in, how to interpret the cases, which is a little bit problematic. They're no longer doing just what's the right economic analysis. They're trying to instruct judges on how to do something that the judges themselves think that is in their wheelhouse. So that's the part that is also the most divisive anyway in what they did. They added to the economic analysis. It's all really good economics. It's the law that they ought to pull back from.
Yeah, and the law was presented in a way that's more than a little idiosyncratic in places, it's lecturing the judges about how to think about the law. It's maybe not the best approach. And I had no sense in looking at the way in which it's evolved that there was much awareness of what had made guidelines successful in the past and what they were trying to do, or even to understand how documents like the 2010 guidelines opened up enforcement possibilities that were not well developed in the past, and that would have been welcome to see that kind of awareness.
Thank you. My point was, by the way, just to connect it to the FTC story. Of course, the guidelines are from both agencies, but momentary weakness in the setup would make this much more of a flashpoint in the context of the FTC, even though you're right that logically it does not differentiate. Now, we could talk more, but I want to open it we have a little bit of time before we give people drinks and other refreshments for some of our audience to ask Q&A. And I know most of the people, but not everyone, so please, say your name, whatever. We have one of our visiting assistant professors here.
Hi, thanks for coming. I'm Daniel Slade, teaching data privacy and externs. I wondered if you could expand more about what you think would best position the FTC to be a more effective privacy regulator here? And do you think that you would emphasize in particular the unique R&D function that they have this ability to use the corporate process? And does that position them, say, in a unique position, in a unique way, to pierce the opacity of, say, the data broker markets?
As you know, there has to be a reformulation of the statute itself. The FTC has some crippling omissions in coverage. The 1914 statute carved out not-for-profits. It carved out common carriers. And Congress subsequently carved out banks. So they thought not-for-profits would always just be humble organizations like the United Jewish Appeal or the Archdiocese of Chicago, and that universities, being truth seekers only, would never have giant athletic programs that brought in billions of dollars. Not-for-profits have changed just a bit, so that you've got to fix those. If you're going to have a comprehensive national privacy program, you've got to get rid of that stuff and to allow universal coverage. That would be part, I think, of an omnibus privacy act that replace the curious, what Dan Solo, my colleague, calls a patchwork of protections to something that's more comprehensive and unified. That's step one. I think the FTC is the right place to send it, though that might not be an evident choice. Would Congress have the stomach to create a new standalone dedicated data protection authority in the style of so many other countries? That would be a legitimate course to take, but I think it would make sense to give it to the FTC. And I really like the fact that the Commission has this research and development capability to do studies about how firms make safeguards work. For remedies in the past that involve sharing of information in the United States and elsewhere, how does that work? To do public consultations that bear upon the efficacy of different programs, and to have an explicit mandate that allows the agency to do more than simply rely on Section 5 of the FTC Act and COPPA and a host of other provisions as well to directly establish privacy-related standards. That's right. I'd build there, and I'd continue to enhance the FTC's capability, which has been developed more robustly over time, to have technical experts involved in doing data-related work, which means engineers, computer scientists, quants, who are expert in the field and understand how these systems operate. Those would be preconditions to making that effective.
Can I jump in really quickly? I think that Daniel's point is really important. You might want to consider adding this to your paper, because I think that there was a lot of expertise in privacy helps us get antitrust right. But I think that there's an idea that these antitrust skills might help us think through some of these privacy issues better, especially like understanding the way that markets work, the ties to when people give up their data. How does that relate to product functionality? And is monetization important for them actually getting higher quality products? And so those antitrust skills might actually help them tackle these privacy questions better.
And I think those perspectives could usefully be brought to bear on coming up with better common solutions. In other countries, the UK is an example, they're integrating the perspectives basically by contract rather than by ownership, where you have MOUs that join up the CMA, the Data Protection Authority, and the communications regulator. That works pretty well, I think, having them in one place and a benefit is that decisions that otherwise would be made in isolation with respect to consumer protection or data protection will be informed by lessons learned from competition. Where can rivalry help you accomplish their aims? That each of the three areas would be better informed by the perspective brought to bear by the other function.
Great. Yes, Kate.
Thank you both so much for coming to speak. Oh, sorry, what? I'll just speak louder.
Yeah.
Sorry. Thank you both so much for coming to speak with us today. My question is prompted by Professor Maciá's comment. I thought it was really interesting, Professor, that you elevated that only 1% of mergers were actually being contested. So I was just kind of curious about thinking about it from a partisanship or policy perspective. do you think that maybe to some degree, it's the perception of inefficiency? So maybe it's not always that something's inefficient, but maybe the way that society perceives it to be inefficient, because I thought that I hadn't been aware of that before this conversation. So I'm wondering if people like kind of assume that things are a different way than what they are, and how that could then kind of ripple effect into like policy issues.
Just the context of that, by the way, for those who have not taken antitrust, is that, of course, only a fraction of all the mergers that need to be reported actually get through, even, just don't fly through very easily. And even among those, there's a process we want to get to it called second request and so forth. There's only a fraction of those that actually is going to be challenged. So the question really is of that probability.
Yeah, I think it just fits into an intuition that people have that, like, if you looked at a company and you saw a company like fighting over both areas want to be responsible for this thing, and they're spending a lot of resources on arguing for that. Even 1%, they might say, oh, that those are resources that could be saved. I think that might be what the focus is, or just this idea that there's two agencies that in theory could get a particular merger case. I think people think is a problem. But again, I think that could be a benefit if you think that like having two eyes on something is good.
Maria, the 1% you're referring to in the GAO report is the number of matters that invoked some kind of debate between the two agencies.
Exactly, yes.
Yeah.
So these would be cases where they both want to work on that.
Right, there are two 1% numbers here essentially.
Yeah.
One is Avishalom's 1%, which is the fraction of the proposed mergers that are, that go to the agencies that actually end up getting some kind of enforcement at the end of the day. But then there's the fraction of the ones that are looked at, that could be looked at by the agencies, that they argue about which one agency should review it, and which is also very low, and which is what Maria was talking about. But on that latter part of the cost of that isn't just that it's it's the isn't really the resource cost. What the merging firms are complaining about is there are these waiting periods and certain and if the agencies have to issue a request for additional information, second request, in like 30 days after the merger is filed, and they spend 29 of them fighting about which agency ought to get it, then on day 30, the one that gets it, it doesn't have time to do any investigation, and they sort of feel like they have to just issue the second request. The merging firms hate that, and what happens in practice is that the merging firms withdraw their merger and then they refile it again. So they get it. But all that just adds to the delay, and the companies all want to get this over with. And so that's what the fuss is about, not the cost.
And the 1% is not a random 1%. That one has to remember, right? The kind of cases the agencies are going to fight over are going to be disproportionately cases that they both think are valuable, interesting, potential, and so forth.
And ones where they have expertise from past work.
The direct obstacle to fixing this is Congress, specifically the rewards that legislators get from performing oversight functions. The FTC and DOJ in 2002 sought to provide a great deal of clarity about this by publishing a far more detailed list of which agency would do which matters, which involves some reallocation of matters between them. On the day that was put out, a very irate Senate Commerce Committee demanded that someone from the FTC come up and talk about that. I was the general counsel. I was the one set up to do that, to talk to the committee staff and by speakerphone to hear the chair of that committee. And what the chair said is, we derive benefits from the perception that you might review mergers across this whole span of sectors. And I said, but the experience base is going down, and said, it doesn't matter. If they think you are a player, they give us respect. And I said, what respect? Money and other benefits. And you're taking it away from us. The difference when you talk to someone who is so mad that the simple, immediate incandescence of their anger prevents them from filtering anything. So they tell you exactly how they feel. And this Senate committee chair, who is no longer a member of the US Senate, said, this is an income stream. And because they think that you're going to look at the richer than get this money. He said, look at my top 20. Secretary said, you're going to get to the Justice Department. This is basically a company that's paying dividends, and you can't throw the dividends. You can't do that. These are your industries. These are industries that we share with you. And you can figure that away. The FTC said, we're going to go ahead and do it anyway. It is the Justice Department that caved in and withdrew it because this same senator was the chair of their Appropriations Committee in the Senate and said, if you don't walk away from this, I can have legislation adopted in 2 weeks that will cut not just your budget, but the budget for the entire Department of Justice by 10%. And I will do it. The Justice Department walked away. And that was a very credible threat. So this, at the time, this was a huge obstacle to providing more clarity about this in a way that would have reduced the cost for everybody. It also happens to be, though, a great protection today against the FTC losing its competition authority. It is the same concern. That is, if you take the competition mandate away from the FTC and give it to the Judiciary Committee, the Congress Committee is going to say the same things. That is, what do we get in return? So in order to accomplish the Musk et al. Redistribution of authority, if they mean to do that, you're going to have to give the committee something back. Historically, that has been the big insurance policy for the FTC's competition commission.
I have one last question, Tony.
Yeah, I'm Tony. I'm a research fellow in Professor Tor's program on economics. And
Is that a good program?
it's an amazing program.
Oh, good, thanks.
Good faculty?
In the committee, you got the spirit of a committee.
Just curious, thank you.
So my questions relate to what you just mentioned. In footnote 7 on page 9, you mentioned that the antitrust enforcement is no longer shared between the DOJ and the FTC, and also that private rights of action play an important role. So I was interested in your view about FTC and how it relates to private enforcement. So are those substitutes, are those complements, are private actors mostly relying on previous regulatory interventions?
Oh, they really are. They truly are substitutes, complements and substitutes. And there are areas in which private rights of action have dramatically transformed entire sectors of activity with no involvement by the federal government. And for double credit for all of you, you can have free food after this and drinks. It'll be on Avi. Can you think of an area of activity where private rights of action have changed the competitive environment dramatically and continue to do so? Cases that the federal agencies did not bring, but private actors did, and they changed the entire area. Can you think of what? Just give me one example. And being at this university, you should be able to do that. It's right over there. It's the NCAA and sports and athletes. It's NCAA versus Board of Regents. It's NCAA and Alston. Private rights of action have transformed intercollegiate sports. They did that. So they are substitutes. Interesting to me, the federal agencies never had the interest in going after anything having to do with the NCAA. It was private actors. So very much substitutes, complements to what the government does in many instances. They go and collect the damages sometimes. But in many instances, they've had the courage. Another area is going after licensure requirements at the state level. Goldfarb versus Board of Virginia State Bar case that you may read as well. Lou Goldfarb was an FTC attorney, and he was doing real estate closing, and he said, talked to a lawyer and said, can you help me with this? The lawyer said, yeah. I said, what are you going to charge me? Well, I'm going to charge you X. And the guy said, whoa, that's too much. I'm going to go to someone else. And said, you can go to anyone else you want. They're going to charge you the same price. Wow. It's fixed. By who? By the state bar. And there's nothing you can do about it. Famous last word. Lou went to his employers at the FTC and said, look what I just found. They said, we're not going to touch it. We're not going to get into the business of wrestling with the lawyers, wrestling with the bar on this. He said, I'll do it myself. To the Supreme Court, he won. So very important backstop in a lot of instances.
Great. Well, thank you very much, everyone. And let's thank our guests. Friday afternoon, the end of the semester, there's including alcoholic breakout sessions.
And
Enjoy.
my antitrust course uses their textbook. So I hope this has been an advertisement.
Sorry. Thank you very much.